Mrs. Perfield.
My lady, before I come on to the question of whether the appeal was a separate act, I will, if I may, revisit the question of Lord Justice Elias's judgment in the Court of Appeal and what its effect is and whether it's right. My lady, the page reference is 178. Lord Justice Elias's remarks, obviously, are remarks that he makes having agreed with the judgment of the Master of the Rolls. And Lady Justice Sharp then also agrees with the reasons given by the Master of the Rolls. So his remarks are plainly obiter dicta in a formal sense. And addressing paragraph 38, where he says at the bottom of the page that insofar as the allegation is the discriminatory treatment of the claimant herself, and he refers to parts of the particulars of claim, he says the focus has to be on the act or acts directed against her, and then he talks about the limitation period and says, as my lady mentioned this morning, Lady Hale, the disproportionate treatment of BME barristers is then potentially evidence of discrimination against the claimant herself. But that, of course, would be a claim for direct discrimination, which is not the claim which survived after the judgment of Mr. Justice Warby. And in fact, the claim of discrimination under contrary to Article 14 has only ever been put on the basis that it's a claim for indirect discrimination, not direct discrimination. And the way that the claim is now put, invoking elements of the way in which the prosecution was brought against the claimant, we say is in fact a claim of direct discrimination. The appellants in their case say, well, this isn't a claim of crude direct discrimination, which I think tacitly accepts that it is in substance a claim of direct discrimination, the way that it's put. And I took the court at the beginning of my submissions this morning to the way in which the case was put in the notice of appeal on the application for permission, and I would reiterate that at page 21, what was being said on behalf of the claimant was that the arguments that the appellant relied on could have been raised by any BME barrister subject to disciplinary proceedings brought by the respondent. We say that's correct in terms of the surviving cause of action, and that it necessarily follows from that the respondent was not under a duty to bring the disciplinary proceedings against any of those barristers to an end by virtue of the claim of discrimination under Article 14. It simply does not, that cannot be the case, that Article 14 requires the respondent to cease to prosecute any of those BME barristers.
Could I ask you about the next sentence of Lord Justice Elias's judgment? He says, the operation of the limitation period has at all times been argued on the assumption that it runs by reference to acts directed against the claimant. So he's saying at all times it's been run on the basis of the first basis of the two which he describes.
My Lord, in relation to the limitation period, yes, it has been argued on the basis that it runs from the prosecution of the appellant, but that doesn't turn the claim into a claim for direct discrimination.
It may not matter what label we put on it for this purpose, but for my part, it does seem that it's necessary to identify the substance of the claim in order to be able to go on to consider the question of limitation.
My Lord, I absolutely agree with that. In the notice of appeal, the claimant says, well, it's not the fact that effectively, in substance says, it's not the fact that the claimant is a BME barrister, it's the fact that she was prosecuted, subject to disciplinary proceedings, that brings her within the class. And so the claimant says that is and it's the fact that she was prosecuted that therefore is the trigger for her cause of action. That's how it's put. And so to that extent, the claimant is saying Lord Justice Elias is wrong. I say that if he's characterising the claim in a way that is actually direct discrimination, then that isn't open to the claimant because of the judgment of Mr. Justice Warby, and that is, it seems to me, what he is doing there.
If one leaves aside for the moment the way in which the claim was put, it's surely possible for an appellant, this appellant, to have a dual aspect to her claim. First, that she has been prosecuted on a charge which is without foundation and has been found to be without foundation, and therefore one has to examine the reason that took place. The second aspect is that she's a member of a BME barrister, if I can put it in that shorthand way. And that's a perfectly feasible way of presenting the case, isn't it?
My Lord, it is, but the first way is an allegation of breach of Article 6 that doesn't survive after the judgment of Mr. Justice Warby. It's only the latter claim which survives, the claim of indirect discrimination.
So you're saying that her claim of indirect discrimination must leave out of account the fact that she has been prosecuted on a charge which has been found to be baseless. That must be left wholly out of account.
I'm saying it isn't part of that cause of action. The cause of action is that more BME barristers were prosecuted than white
What I'm trying to
barristers.
get at is, what is the consequence of that? Are you saying that it has to be left out of account when examining the Article 14 claim?
Yes, it's not relevant for the purposes of the indirect claim.
So she can't introduce that as an element at all?
Well, we've heard you say that. You said it at some length this morning, and I think we've gone on long enough about this particular aspect of the matter. Clearly, people have to complain about some adverse treatment. That's what discrimination claims are all about. And the question is what the reason for the adverse treatment was.
Turning then to the question with which I left off just before the short adjournment, the Court of Appeal, of course, held that opposing the appeal was a separate act from what they held was a continuing act in terms of prosecuting the disciplinary proceedings up to the decision of the disciplinary tribunal. We say that if they were right about the latter, they were also right about the former. So if it's continuing, then they're right that the appeal is separate. We say that in part because the disciplinary tribunal is, of course, a separate body from the respondent. The respondent is prosecuting before the disciplinary tribunal, but it's not responsible for the acts of that body. One might say there are dicta in the authorities to the effect that, of course, it's the court which bears the primary responsibility for upholding or ensuring that the claimant has a fair trial, although there may, of course, be acts of a prosecutor which breach Article 6. And so we say, once the disciplinary tribunal has made a decision, that is an act of a separate body, separate from the respondent. And at that point, unless somebody takes positive steps to appeal that decision, that is an end of the matter. And so an appeal, if it is brought, is a separate act, so any opposition to the appeal by the respondent, is a separate act from its earlier act in initiating and, on this hypothesis, continuing with the prosecution before the disciplinary tribunal. And we say that comes out inherently in the nature of an appeal, but also from the hearings before the visitors' rules, which require the claimant, the defendant before the proceedings, if he or she wants to appeal, to serve written notice of intention to appeal against the relevant decision. So it's plain that the appeal is against the decision of the disciplinary tribunal. There's prescribed information. The rules are at tab 5, page 628, just as a reference. The respondent may serve an answer to the petition or may be directed by the directions judge to serve a petition. So it is possible for an appeal to go ahead without any opposition in terms of a written document from the respondent at all. Rule 14 provides that the hearing may not proceed in the absence of a representative of the Bar Standards Board. So clearly there is a required role there written into the rules. But nonetheless, the appeal is against the decision of the disciplinary tribunal. The visitors are considering the merits of the disciplinary tribunal's decision, not the merits of the prosecution brought by the respondent. And because the tribunal has made a finding, which is how a conviction is described in the rules, a decision of the visitors is required in order for the appeal to succeed, whether or not the respondent opposes the appeal. So even if the respondent supported the appeal, it would still be necessary for the visitors to make a decision because the disciplinary tribunal has made its decision in the proceedings. And on that basis, the role of the respondent on an appeal is plainly fundamentally different from the role that it undertakes as a prosecutor when it is preferring charges and then taking the various steps required in order to bring the case before the disciplinary tribunal, at which point it could, the complaints rules provide, and I've given the references in the respondent's case, it could offer no evidence and therefore bring those proceedings to an end. But it's different once the disciplinary tribunal has made a decision, and it's that decision which is the subject of the appeal. And on that basis, we say that the Court of Appeal was right to say that they are different, they're different acts, and they are separate acts. The acts of the respondent in before the disciplinary tribunal and then subsequently on appeal. And if that is right, it is of course significant that Mr. Justice Warby found there wasn't any evidence of indirect discrimination in relation to steps taken by the respondent to oppose an appeal or otherwise. My learned friend dealt with the Somerville case. I agree with him. I think that I'm not sure that Somerville really helps all that much. Obviously, it's all obiter, and there's a range of views expressed. For our part,
but I think it's about as unhelpful as it possibly can be to have a decision where it's obiter, two views are expressed in one direction, two views are expressed in another, and number 5 doesn't say anything.
Yes, it's arguable.
What are we going to do? I think we're going to make our own minds up.
My lady, that really would be my submission on that. We would prefer the approach taken by Lord Scott, but I won't try and explain in words different from his lordship why that might be the correct approach. In relation to a failure to act, just dealing with the point of how does that accrue in terms of time, I think it was my Lord Wilson who said this morning that why should it be day by day, why not hour by hour or minute by minute? I think the answer to that is probably in the statutory language, which talks about the date of the act complained of. So I think that's probably why Lord Scott was talking about day by day happenings. Picking up on another point from Mr. Anderson's submissions, the practicality point, well, this puts a claimant in a very difficult position. How are they to know what to do as between the decision of the disciplinary tribunal and the appeal? They are, of course, in a difficult position in that situation. But that is exactly the sort of difficult position that potential claimants are frequently placed in applications for judicial review, which, of course, have a very short time limit. And they may well have to think about whether they're going to issue a claim at a point where they don't really know what the ultimate outcome of a decision or an act is going to be. And of course, the 3-month time limit for judicial review is much shorter than the 12-month time limit in the Human Rights Act. And in many cases, it will actually be the 3-month time limit that applies rather than the 12-month time limit, depending on the claim that's being brought. And then finally, of course, there is Section 7(5)(b) and an equitable extension of time. That isn't available, as the court knows, to the claimant in the present case because of the decision of the master because of the decision of Mr. Justice Warby that the master was right not to consider whether to extend time of his own motion, and the decision of the Court of Appeal to refuse permission to appeal on that point. So that, of course, is why that isn't available in this court, but it would normally be available to a claimant, and of course one sees that from the judgments in Somerville.
So I suppose what you're saying is don't distort the natural and ordinary meaning of 7(5)(a) because 7(5)(b) is not available, because in most cases it would be available.
My lady, that's it exactly, yes. And essentially that some of the difficulties experienced by the claimant in this case arise partly because of her inability to invoke at this stage Section 7(5)(b). My lady, those are my submissions on the time point. Mm-hmm. Your ladyship invited me, I think, to deal with the question of whether the court should hear me on what I call my respondent's notice point.
Yes, you've already said quite a lot about the nature of the claim and what you think of it in dealing with the limitation point, have you not? We're not inclined to allow you to adduce any fresh evidence at this stage. We think that would be totally inappropriate. You can seek to persuade us that we should ask ourselves whether Mr. Justice Warby was right even to allow the claim to go forward on this limited basis.
My lady, do you mean that I can seek to persuade you that you should hear my argument on that?
Yes. But don't take long to seek to persuade us.
My lady, I won't. The reasons are essentially those set out in the respondent's case at paragraphs 51 to 55 So that's page 160 and 161. It may be convenient if the court wishes to read those rather than me articulating them.
Yes, paragraphs 51 to 55.
51 to 55, my lady.
Right. Well, let us read them, or remind ourselves of them, because I'm sure we've all read them before.
But these paragraphs are just you saying, Ms. Padfield, that you don't actually need permission to articulate this respondent's notice. And I think my lady has already really gone beyond that and said, come on, Ms. Padfield, briefly, what are your points? So we're beyond your not needing permission.
My point on the respondent's notice?
Yes.
Or?
Yes, let's have those quickly. I mean, it is open to this court to say that we're not going to even consider your respondent's notice because it doesn't raise a point of law of general public importance. We could say that. The fact that you can raise it is quite separate from the fact of whether we are going actually to entertain it. These paragraphs are addressed to the raising rather than the entertaining. So, my lord is completely correct. What you should be trying to do is to persuade us there's something in it.
My lady, on that basis, as my Lady Hale said a moment ago, I have already set out in some detail for the purposes of the time point the substance of the basis on which we say the Article 14 indirect discrimination claim arises, and essentially, for those reasons, we say that the statistical evidence, well, we say, of course, that Mr. Justice Warby was wrong to say that there was one claim which was adequately pleaded and supported by adequate evidence. But the reason that we say that is because the evidence in the Inclusive Employers report simply showed a disproportion. That's all. It didn't go any further. It didn't say that if you would just give me a moment. It didn't show any didn't say anything about the degree of the disproportionality. Simply a bare difference in the proportions. And in addition, as I said earlier, the report itself went through very carefully the process adopted by the respondent in relation to prosecuting barristers and making decisions about when to refer somebody to a disciplinary tribunal. And it concluded, and the methodology is described in detail in the report, it concluded that the process itself was not discriminatory. And we say that that is not anything like enough to give the claimant's claim a real prospect of succeeding on the basis of DH. And if I could just say something about the report itself, partly because it's been described by the appellant as being expert evidence. That's not correct. The report itself is one of a series of reports, including the 2016 report, which Lady Hale has indicated the court does not wish to receive in evidence. But these are reports prepared by the Bar Standards Board in the exercise of its regulatory functions under the Legal Services Act. And this is set out in footnote 59 of the respondent's case at page 158 in bare terms. But essentially, the Bar Council is an approved regulator under the Legal Services Act 2007 and exercises its regulatory functions through the respondent. And it has a duty, a statutory duty, to promote the regulatory objectives under Section 1 of the Legal Services Act, which include encouraging an independent, strong, diverse and effective legal profession. And it's in the exercise of those functions that the earlier report, which isn't in evidence, but which the purpose of which is summarised in the Inclusive Employers report, was produced by the respondent.
We've
and
got
as the
relevant report in Appendix Part 2, page 312. Have we not?
Well, my lord, yes, that's one of what are now a series of 3 reports produced by the respondent looking at this issue.
Is this the one upon which the appellant relies?
My lord, it is.
And they looked at complaints between 2007 and 2011. I'm looking at the top of 314. So that would include the complaint referable to the appellant, would it not?
My lord, yes. Or the complaints, yes.
And the conclusions which they draw are at the bottom of 314. BME barristers disproportionately overrepresented in relation to the outcomes of the external complaints, more likely to have a complaint referred to disciplinary action, more likely to be subject to a disciplinary action outcome of upheld, disproportionately overrepresented in the complaints process in relation to internal complaints. And then if we go back to 313, first paragraph of number 2, 4th line, this research did not point to any clear reasons for the overrepresentation. So it raises questions, doesn't it? And questions which it is for your board to answer.
My lord, the summary on pages 3, it's 313 to 314 in Appendix 2. It's 477 to 478 in the electronic copy. That is a summary of previous reports. So starting with the first report, 2007 to 2008, that's under the heading Background to the Report. Further internal research by the Professional Conduct Department, of the respondent, was undertaken in 2010. However, this research did not point to any clear reasons for the overrepresentation, and then it goes on to describe it. The next report, this is the final paragraph, 2009 to 10, showed that the disparity was still there. Further research was conducted, and a report was prepared by the Bar Council research team covering the period 2007 to 2011. That is a report which was then presented to the board of initially the Respondents' Equality and Diversity Committee, and then to its board at the tail end of 2012. And it is that report which is summarised, the content of that report which is summarised on the next page, on page 314. So summary of key issues arising from the 2007 to 2011 data explains why inclusive employers are examining the process. So that's the background, and then they go on to examine it and provide their conclusions at the end. But these are not the conclusions of inclusive employers. They're the conclusions from the 2012 report, which isn't in evidence.
Conclusions of the 2013 report are at 324.
My lord, that's correct. Well, there's a summary on the previous page. This is 487 and 488. So there's a summary on the previous page, which is more detailed. And then there is a conclusion. Yes.
You say it leaves the question open. This means that other factors as yet to be identified are causing the disproportion shown in the data.
I say that this report shows that the procedure itself isn't discriminatory. And the 2016 report, which the respondent has since prepared, explains the disproportions in the data. But
Well, we're not going to.
yes, the court has indicated that it is not going to admit that in evidence. But
Well,
that's
we're not
the
going to
sequence.
resolve issues of fact of this nature. We're not going to do that. We've just got to see whether there's anything for the appellant to complain about. And she, of course, also wanted to introduce another report and was not permitted to do so before Mr. Justice Warby.
My lady, Mr. Justice Warby didn't find it necessary to decide that question.
Yeah, but she wasn't allowed to do it, so...
Well, that application hasn't been pursued on appeal past Mr. Justice Warby. But if the court is inclined to look at that report, I should make clear that the reasons why we opposed it being adduced in evidence are partly because it confused the 2012 report and the Inclusive Employers report, and thought that the Inclusive Employers report had suggested. Well, if the court looks at it, I would ask the court to bear that in mind. We say that evidence really goes nowhere, and that's why we opposed it, and it isn't in evidence. But it's not correct to say, as the appellant does, that report in some way contradicts the 2016 report. Lady, unless I can assist further, those are my submissions.
I think we've asked you all the questions that we want to ask you. Thank you very much, Ms. Padfield. Thank you. Yes, Mr. Anderson.
There's just one point of reply which isn't about the merits of the respondent's notice. In taking into account, as I know this court will, that there is section 75B for those who invoke it, I do invite the court to bear in mind that section 75B would not have been available for Portia O'Connor in this case, according to Mr. Justice Warby, who said that even having heard Mr. Hughes Southwick QC explain all the reasons why it should have been exercised, he wouldn't have exercised the discretion in favour of the claimant. Mr. Justice Warby's position, judgment, was that you simply have to go and issue your writ and your claim form, and negotiate with the other side or with the court as to how to deal with the problem that you've now got a claim afoot that is premature. So section 75B doesn't provide an answer in this type of case, apparently.
But you say he's wrong to say that, of course,
Well,
for other reasons.
I'm not allowed to say he's wrong because I haven't got permission to do
No,
that.
but you say he was wrong to say you could negotiate the problem away.
Oh, yes, sorry, yes, I do.
Yes,
I do say.
You've said that, and you have said, and therefore the construction adopted by the courts below doesn't make sense in this sort of context.
Yes, but the problem is that with Parliament clearly intended that applicants have a year before they have to worry about whether they can persuade a judge to exercise a discretion in their favour. And we submit that this court should make sure that they get that year. Now, as to the respondent's notice, we only get to the question of whether Mr. Justice Warby was right if the appeal succeeds or would otherwise succeed on the issue of limitation. And so it would follow that if you give consideration even to Ms. Padfield's submissions, that the BSB respondent would have achieved a hearing in this court against an appeal in this court effectively against Mr. Justice Warby's decision, which it would never have obtained had it not taken the ex hypothesi bad limitation point. I say that that's a very relevant consideration, as well as the consideration which my lady raised that it doesn't actually raise a point of general public importance. It's important to bear in mind that even the respondent's notice type of appeal is quite limited. If we look at Mr. Justice Warby's judgment, paragraph 24, 187. He was faced with two applications by the Bar Standards Board, which he describes here. The first is under Part 3.42, on the basis that the court may strike out a statement of the case if it appears to the court that it discloses no reasonable grounds for bringing or defending the claim. That's the pleading point. It was said there was no proper claim pleaded. And then under summary judgment provisions of 24.2, summary judgment because the claim has no real prospect of success anyway. And the respondent's notice at page 50 makes clear that the appeal that the respondent wishes to bring against Mr. Justice, finding that there was a case that can go forward, is not on the basis of the pleaded. It's not under Part 3.4. But is only against the finding that the claim which Mr. Justice Warby found to have been pleaded has no real prospect of success. So the issue for this court is not do the particulars of claim as formulated plead a cause of action. Mr. Justice Warby has decided that, and that isn't challenged. The issue is there any real prospect of the claimant succeeding on the evidence with that claim?
Did you say that was at 50?
Page 50. Yes.
Thank you.
Yeah. And then, Ms.
Yes,
Bradfield-
wrong to hold that the Article 14 claim had real prospects of success.
Yes, that's it. And Ms. Padfield, in case that anyone thinks that's a mistake, if we go forward to page 56, the same point is repeated in Ms. Padfield's helpful amplification of that document. So, as I say, it's a very limited appeal, which is confined to the facts of this case, and is, in my submission, a wholly inappropriate vehicle by which to travel the road of DH and Orsus, the plight of the Roma children and so on. That really this court should be waiting for an opportunity to look at all of that when facts have been found and not before. So there's no point of public importance, I say, and anyway, it would be a very adventitious appeal arising in circumstances where we're only here because of the bad limitation point, if we get that far. Those are my submissions on why this court shouldn't hear the appeal. May I proceed briefly to deal with the merits of the case? Thank you. The charges that the claimant faced are set out in the bundle at page 212. They were conducting litigation and discreditable conduct. And if we look at the judgment of the visitors at page 217, we can see how Mr. Justice Collins dealt with those matters. And the parts I would highlight are at paragraph 30. It's somewhat strange that the ESB decided to persist in the prosecution of the appellant for doing what their current guidance, then current when the proceedings were brought before the tribunal, recognised not to be covered by the conduct of litigation. And over the page at paragraph 33 in relation to charge 5, at the end of paragraph 33, when one thinks of it, it seems somewhat absurd that to send a copy of a statement of case which is to be lodged or indeed which has been lodged with the court to the other side is to be regarded as conduct of litigation and so forbidden to the barrister dealing with direct access. Paragraph 37, in the second line, these are significant words, I submit. We doubt if anyone looking at this case would take the view that even assuming the sending of that letter was something which the appellant should not have done, it could be regarded as discreditable in any way. Quite the contrary, showing courtesy to the other side. And that's why the visitors had no doubt, as they put it in paragraph 38, that none of these charges can stand. If we then turn to the Inclusive Employers Report, I know we've just looked at that, but there are a couple of other points about it. It's page 478 that I would highlight.
Other number, please.
314 is
Thank you.
paper number. Padfield has already taken you, or you, her, I think, to this page. But if we turn over 3 pages, under findings, there are some worrying findings in this report. The last 2 lines of that paragraph, equality and diversity training for committee members, that's the committee who decided to bring the prosecution.
Forgive me, which page?
481. 481.
481. Final 2 paragraphs of findings. Equality and diversity training for committee members is in place.
I'm sorry, I
Sorry,
don't...
483.
483.
That's more like it.
Other page number, please.
319.
Ah. Thank you.
Right.
So, equality and diversity training for committee members is in place, although this does not always occur prior to them joining the committee. The focus of the equality and diversity training is the legal framework. And then turning forward 2 pages, scrolling down 2 pages, in recommendations, number 1, equality and diversity training should take place within 3 months of joining for all BSB committee members. And number 2, the equality and diversity training should be broadened from the legal framework to include training in unconscious bias. So the decision to prosecute the claimant was taken by a complaints committee that apparently had not been trained, at least not as part of their functions with this respondent, had not been trained in unconscious bias, and in some cases had possibly had no diversity training at all. And that led to what Inclusive Employers described at page 322, paragraph 10, which I think is 486. Under findings, in the 6th line, the statistics showed up stark anomalies, exposed stark anomalies was the phrase which they used. So there is a lot in this report that gives cause for concern. We submit that it's entirely appropriate to adopt the approach that Lord Kerr has adumbrated, that there's a lot wrong with this prosecution, even apart from this report. You asked for an explanation, and this report is something that has to be taken into account in evaluating whatever explanation is given. Whether that's direct or indirect, it is something that isn't to the point, unless you're taking a very dry pleading point. I submit, we submit, that it isn't at all clear that the distinction between indirect and direct discrimination Learned Friend relies on actually applies to the Strasbourg jurisdiction and therefore to the Human Rights Act. That is a matter for another day, which can be much more easily decided once the facts have been decided. We submit on the basis of DH that there is a burden on the BSB to account for statistics which apparently evidence discrimination. If the statistics were all that there were, they apparently evidence discrimination, we submit. And therefore, the BSB have got to prove that discrimination did not play any part in the decision to persist, to begin and to persist in this prosecution. And of course, that hasn't. This is no criticism of the BSB. It hasn't yet even been attempted. The doesn't provide any such explanation. In paragraph 13, as Lord has pointed out, although the procedure, the word isn't process, by the way, the procedure itself is not at fault, there are other factors yet to be identified that are causing the disproportion shown in the data. Now, who knows whether those other factors included unconscious bias or anything else? I mustn't be tempted into suggesting what it might be, because we submit that that isn't our job, that the BSB have got to start that ball rolling. And the fact that the prosecution was so hopeless and should never have been brought does make it less likely that the BSB will escape liability by justifying the prosecution by reference to the evidence which it had to support it. This isn't a case where discrimination could be discounted because anyone in the claimant's position would obviously have been prosecuted. It's not such a case at all. Now, dealing with the argument that the claim in indirect discrimination would mean that all BME barristers subject to prosecution could insist on having their prosecutions stopped once this evidence had come out. That isn't right. What all BME barristers might have been able to do is to insist that the decision to prosecute them be reviewed by the BSB once it had realised that that its prosecutions were being informed by inappropriate matters, and once that particular evil had been excised, that they could then have demanded that their prosecutions be reviewed as to whether they're appropriate or not. Many prosecutions, perhaps most, don't involve an exercise of discretion by the prosecutor as to whether to bring them or not. I mean, if Mrs. O'Connor had been caught with her fingers in the till or something like that, then it wouldn't matter what statistics were available about BME barristers. She would have been prosecuted, and she would hardly lie in her mouth to complain about that when the statistics came out, because she was obviously, in that situation, was obviously accused of something that ought to be prosecuted. But it's the cases where barristers are subject to prosecutions when the decision to prosecute was by no means obvious. Those barristers would have been entitled at least to have their prosecutions reviewed, but not automatically to have them annulled. Of course, in the DH case, it was different. The reason that you didn't look in the DH case at the individual cases was you didn't need to in that case, because those children had been educated, or that's not the right word, they'd been sent to special schools, which the courts found to be inadequate schools. If one goes briefly to DH, it's in the second bundle. 1251.
I'm sorry,
1251.
Thank you.
18 in the paper version. Ms Padfield relied on paragraph 209 as the paragraph that shows you don't look at individual cases. But if you look at the facts in paragraph 207, the facts of the instant case indicate that the schooling arrangements for Roma children were not attended by safeguards that would ensure that in the exercise of its margin of appreciation in the education sphere, the state took into account their special needs as members of a disadvantaged class. Furthermore, as a result of the arrangements, the applicants were placed in schools for children with mental disabilities where a more basic curriculum was followed than in ordinary schools, and where they were isolated from pupils from the wider population. As a result, they received an education which compounded their difficulties and compromised their subsequent personal development instead of tackling their real problems or helping them to integrate into the ordinary schools and develop the skills that would facilitate life among the majority population. So all of the Roma children had been sent to inadequate schools, and that was enough. They'd been educated in an inadequate, in a duff system, and that's why they all got compensation. In the present case, the claimant would have to, I think we may have appeared to concede the wrong burden of proof in our printed case. The claimant has to secure a finding at the end of the day, at the end of the trial, that her prosecution had something to do with discrimination, that the decision to prosecute and to continue the prosecution was informed by discrimination in some way. The exact test that she will have to satisfy isn't a matter for today, but the prosecution is vital at the heart of her case. Those are our submissions.
Thank you, Mr. Anderson. I think technically, Ms. Padfield, you probably have got a right of swift reply on the second issue, on your counter notice. But if there's nothing more you want to say, feel free to say nothing more.
May I just consider that for one moment, my lady? Because I wasn't given
I think technically it's in the nature of a cross appeal. Though you can see how much enthusiasm we've shown for it.
my lady, I have indeed noted that. Lady, no, I won't trouble you any further.
Thank you, Miss Padfield. I thought you ought, in all fairness, to have the opportunity. But there is no need to avail yourself of it if you don't feel you need it. Thank you very much indeed. And thank you to everybody who's been involved in preparing and making the submissions to this court. It's by no means a simple case. We are grateful to you all. We will go away and think about it and let you know the outcome in the usual way.